You're pretty familiar with this already, as we went through a whole bunch of it when we did civil liberties, and we talked about some of it way back at the beginning of the year as well. So, this should be relatively familiar. Supreme Court is the final arbiter of disputes in the American justice system. You cannot go higher than the Supreme Court. Full stop. There are no exceptions to that rule. They hear about 80 cases a year, and the high end. Some years they'll only hear 30 cases. They do not really need to hear any. It is their choice what cases they will hear. And we'll talk about how that works out on the next slide, or in two slides. First of all, I wanted to point this out to you before we get any further. This is former Justice Antonin Scalia. He's a former justice because he passed away a couple years ago. And one of his best friends, current Justice Ruth Bader Ginsburg. I show this because A, it is a fantastic picture and I find it absolutely delightful. And B, Ginsburg is one of the most liberal justices on the court and has been her entire time there, whereas Scalia is one of the most conservative justices and was always so. So the Supreme Court, for the most part, really does view itself as a family and do not want to get involved in petty squabbles. They view their job to interpret the law. As it says right here, this is a quote from Justice Marshall's decision in Marbury versus Madison. It is emphatically the provenance and duty of the judicial department to say what the law is. It is this court's duty to interpret the law and the legality thereof. Applied via the Constitution, is it okay that the thing was done, yes or no? They do this via a process called judicial review, which hopefully you remember. This is the power to declare laws unconstitutional. It is not always just laws. It can also be executive orders. That's what this refers to right here, quick appeals. For example, when the president instituted the travel ban a couple years ago, it was appealed to the Supreme Court. Most death penalty cases are appealed to the Supreme Court, and those can be decided relatively quickly. Again, just like a normal case, the Supreme Court has to decide that they want to hear it. Marbury versus Madison is the case that makes the Supreme Court. The Supreme Court does not exist in its current form without Marbury versus Madison. As you remember, John Adams tried to appoint a series of Federalist judges to the Supreme Court, to circuit courts right before he left. Those letters were not delivered by incoming Secretary of State James Madison. One of those judges that was expecting the job, William Marbury, sues Secretary of State Madison and says, hey, you've got to give me that letter because you're denying me my job. Madison says, no, I don't. Not my problem. Go away. They end up in the Supreme Court where Justice Marshall makes a very, very clever decision. He basically says that I can't make a ruling on this case. Because remember, if he rules for Marbury and says, yes, you got that job, hand over the letter, Secretary Madison, Madison and President Jefferson can just decide not to do that, at which point the Supreme Court looks weak. Or he can side with Thomas Jefferson, his much reviled cousin, and basically say, yeah, the Supreme Court's just going to do whatever the president says. He doesn't want to do either of those. So instead he says, hey, guess what? The law is unconstitutional. Therefore, I can't make a decision on this. Brilliant. By declaring the law, the Judiciary Act of 1789, unconstitutional in part, he was able to avoid that issue and basically create for the Supreme Court the power of judicial review. As it says right up here, he wins. John Marshall wins and goes on to issue a number of Supreme Court cases, many of which we've talked about already. So let's look at who the current justices are. I'm not going to make you remember this, but they come up in the news enough. The only name I need you to pull out of this is who the current Chief Justice is. The Chief Justice is not chosen by the Supreme Court. It is not a seniority thing. You are appointed to be Chief Justice by the President. So, for example, if John Roberts were to leave and not be our Chief Justice anymore, and President Trump wanted to make Clarence Thomas our new Chief Justice, he would need to nominate Clarence Thomas to be Chief Justice of the Supreme Court. He would need to go through the entire rigmarole of the Senate approval process, just like any other person nominated to be Chief Justice of the Supreme Court, and then he would need to be confirmed by the Senate. And after that, then you would need to fill Clarence Thomas's seat. So it is not just a promotion, it is a specific role. So the role of the Chief Justice is the final decider. They're the ones that kind of have to manage the rest of the Supreme Court. So this is Chief Justice John Roberts right here. Very well-respected jurist, had argued multiple cases before the Supreme Court before he was appointed to the court by President George W. Bush in 2005. Over the past couple of years, he has been relatively moderate, which is why I have this up here. You will notice for the rest of them, I have them marked down as either liberal or conservative. They do not ascribe officially to political parties, so you wouldn't say that's a Republican justice, that's a Democratic justice. Instead, they lean conservative or they lean liberal. So remember, if you lean conservative, you don't want things to change. You are usually going with a strict interpretation of the Constitution. Does it say this? Yes or no? That means, is it okay? Yes or no. Whereas a liberal-leaning justice would be much more of what we saw in our civil liberties unit, which is more along the lines of, is it beneficial for the American people? Then I might be okay with it, and I can sort of twist what the Constitution says to fit this. Both are equally valid interpretations. It really depends on the individual justice. Earl Warren is sort of your textbook version of a liberal justice, whereas Antonin Scalia, who we talked about a minute ago, is your textbook conservative justice. So, who sits on the court now? The most senior member of the court is this gentleman right here, Clarence Thomas. Clarence Thomas is not particularly well liked in judicial circles. I think that's the best way to put it. We've talked about this before. There was a scandal during his appointment when it turned out that he had repeatedly sexually harassed one of his coworkers, named Anita Hill. You can look into that more on your own. Also, he's not particularly well respected because he goes back on his decisions a decent amount. Just like 2-3 weeks ago he did this. And also, he doesn't talk. The Supreme Court asks questions of people while they are making their arguments in there, and Clarence Thomas goes years, sometimes without talking, to the point where it is actually national news that, hey, Justice Thomas actually spoke today, actually asked a question. Next up, we have Ruth Bader Ginsburg, right here. Civil liberties attorney before she becomes a member of the Supreme Court under Bill Clinton. Very left-leaning justice. Old, frail, probably not going to serve much longer. It is supposed right now that were the Democratic candidate to win this year's election, that she would probably step down immediately after that person was sworn in to allow them to appoint a new justice. One of the big knocks, actually, and we didn't really get around to this in that Frontline video we watched the other week, against the Obama presidency, was that the Democrats and Obama did not take appointing justices seriously, and as a result were kind of dragged their feet on that and left a number of older liberal justices in the court for when Donald Trump came in and appointed conservatives to replace them when they retired or passed away. Next up, we've got Stephen Breyer. Stephen Breyer is this gentleman right here. Stephen Breyer, very opinionated, has sort of drifted from a centrist to more of a liberal over the years, and has remained that way. Very much a sort of, what does the Constitution say now versus what did the Founding Fathers originally mean? So he's more of the Constitution is a living document sort of guy. Sam Alito is this guy over here. Alito is a Bush appointee from 2006. He doesn't do much. He's sort of a background player in the Supreme Court, whereas people like Roberts and formerly Scalia and also Breyer were much more sort of outspoken dudes. But he's sort of coming into his own, but rather conservative justice. Not as conservative as Thomas, but pretty dang close. Next up is Sonia Sotomayor. She's right here. Sotomayor was a judge in New York City, I believe, at the federal level before being appointed to the court by President Obama. Very liberal, very outspoken, as is the next member that came in soon after her, Justice Kagan. Don't know a ton about Elena Kagan. She is kind of like what we said about Alito, more of a background judge where she listens more than she questions. Not to the degree of Clarence Thomas, like we just talked about, but lets other people take the lead more often than not. Neil Gorsuch is this tall dude right over here. Pretty new on the court. Respected. There was some issue with him just because what Mitch McConnell did in the last year of President Obama's presidency was he blocked the person that Obama wanted to put on the Supreme Court. And McConnell basically argued that it's an election year. You should not be able to appoint anyone to the Supreme Court. You should let the next president decide that. Of course, Senator McConnell has since said that if Ruth Bader Ginsburg were to pass away tomorrow, she is definitely the oldest justice on the court, and she is also like a 4-time cancer survivor and pretty frail. That if she were to pass away, that he would confirm another justice within weeks. So, again, Mitch McConnell, way better at the politics game than his Democratic predecessor, Harry Reid. And then lastly is Brett Kavanaugh. You're all familiar with Brett Kavanaugh from the appointment hearings last fall, or 2 falls ago, I guess, fall of your junior year. Pretty well respected jurist on the DC Circuit Court, and seems to be more of a swing vote than people thought. But if you count this up, we've got 4 very conservative leaning justices, 4 very liberal leaning justices, and then we've got Chief Justice Roberts, who's very aware of the fact that people look to him as the swing vote at this point. He is the tiebreaker. And he does not want the court to be seen as kowtowing to any president, be that President Obama or President Trump. He wants the court to remain, like John Marshall envisioned, an autonomous body that does not answer to either either the legislative or the executive branch. He's very cognizant of his legacy and is more likely in the last couple of years to split with his conservative brethren than most people would have thought. But, that changes case to case and year to year. So make sure you know Chief Justice Roberts, if nobody else. I'm not going to make you know all of these guys like I made you know the order of succession. There is no order of succession for justices, by the way. These guys are all just considered associate justices, and there's the Chief Justice. Chief Justice dies, you can either nominate out of here, or you could nominate anyone else. So no qualifications to be a justice either. Some are judges beforehand, some are lawyers beforehand. Goes both ways. All right, moving forward. How does the Supreme Court work? Well, there's a lot here, and these 2 videos you see on the right-hand side, I am not going to watch them now because I think it would be weird and Inception-y to watch a YouTube video in a YouTube video. That would just be weird. So instead, I'm going to ask you guys to watch both of those later. They're both pretty short, and they're both pretty interesting. So how do we get to the Supreme Court, first of all? That's this right over here. First of all, as we talked about yesterday, the Circuit Court of Appeals is going to basically act as the buffer zone between district courts and the Supreme Court. So the Supreme Court is not going to listen to the vast majority of cases. They're instead going to say, hey, the lower court was completely right. They made the right call. We don't need to hear that case. Listen to what they said. If you want to hear a case, 4 or more justices must agree to hear that case. Usually what will happen is one justice will be super excited to hear a case and will sort of wrangle other people together with them. Next up, the case will then be put on what is called the docket, which is basically the calendar for the next session. So you're not going to hear a case unless it's an emergency right away. Instead, you will hear it the next year. Then, once a case gets into the Supreme Court takes the summers off. They usually wrap up in late May, early June, and then they'll pick up again in September or October. What they'll do is they will hear what are called oral arguments for 2 weeks. We'll go over that in a second. And then they will take 2 weeks off and decide on the batch of cases that they just heard, and then they'll have another 2 weeks on, and then another 2 weeks off, and it just goes back and forth throughout the year. But there you go, October through June-ish. So, what happens? You, as a person whose case is being heard by the Supreme Court, will file a brief with them. usually more than 50 pages. There's a lot there. And it's going to be an explanation of your side's argument. So here's what my side arguing, I don't know, Texas v. Johnson is going to say. So here's what my argument for the constitutionality of flag burning is. And I'm going to list off a bunch of other cases. There are sometimes what are called amicus briefs filed, which will be other groups of lawyers will say, here's my interpretation of the Supreme Court. Look at this as well. And amicus means friend of the court. So you're trying to help the Supreme Court in making its decision. But you'll put this in, and then the other side will put in their brief as well. So the state of Texas is going to say, here's why we don't think that burning the flag is okay and is not constitutional. But the Supreme Court will then read through both of those arguments. So the Supreme Court will know basically the entire history of the case before it shows up. Because in the stage of oral arguments, number 2 here, each side only gets a half hour to argue its case. The Supreme Court can extend this if it wants. Normally they don't. Because while you have 30 minutes to argue your case and the lawyers will plan to speak for 30 minutes, sometimes they'll speak for 30 minutes. More realistically, though, they'll be interrupted about 30 seconds in, and the justices will just ask them questions the entire time. So those 9 justices will have questions ready. They will have read those briefs. Their law clerks, who are excellent lawyers in their own right, will have read those briefs and help the Supreme Court to come to interpretive decisions on them. So judges get to interrupt and basically ask any questions, and if they want more time, they can take more time. Sometimes judges don't even listen to you. Sometimes they've already made up their mind, and there have been cases where Supreme Court justices will literally just have a conversation for a half hour and not listen. That's a rarity, but it can happen, and there's nothing illegal about that. Then, once oral arguments are over, judges will go into what is called conference. They will look over the case. They will look back over the notes of the oral arguments. They will do research into the legal questions at hand. They will have their clerks do research into the issues at hand as well. They will meet up with other judges. Each of them has an office in the Supreme Court building in Washington, D.C., which you saw 2 slides ago on the bottom left. And they're going to come to some sort of personal decision. So John Roberts is going to say, this is my decision on it. Sonia Sotomayor is going to say, this is my decision. Clarence Thomas is going to sit silently and slide a piece of paper across the table that says, this is my decision. Once conferencing is over, then we are going to reach the opinion stage. And the opinion is what the court's final ruling is. So what does the court decide? Is thing X constitutional or unconstitutional? Is it okay to burn the flag? Is it not okay to burn the flag? The way this will be written is it is the senior majority justice. It's their call to, hey, there's a video. It's their call if they want to write it or not. So right now, if it were a Republican, your senior majority justice would be Clarence Thomas. Your senior liberal justice would be Ruth Bader Ginsburg. Now, judges do not always vote based on their political leaning. Earlier this year, Neil Gorsuch leaned left on a couple cases. Sonia Sotomayor will occasionally lean right. It happens. Sandra Day O'Connor, not Sandra Day O'Connor. She passed away a couple years ago. Ruth Bader Ginsburg has leaned right on cases before. It happens. So it's the most senior justice on the court, not the oldest, but the one who's been there the longest. Unless the Chief Justice is in the majority. Then the Chief Justice has 2 options. They can either write the decision themselves, or they can delegate somebody to write the decision, and then everybody will sort of look that over. So what that means is the majority opinion is going to be what is going to hold the legal weight. Now, each justice still is entitled to write their own opinion. So you can get 9 decisions. You'll usually get at least 6 or 7 out of every single case with each justice arguing, hey, this is my point of view on how this should be done. But the majority opinion is the only one that holds legal weight. That is the official opinion of the court that the chief executive will then have to enforce. So sometimes what will happen is you will get a majority and they will write that, hey, I think thing X is constitutional, and each one of them will give a different reason. So The majority opinion is simply the one written by either the Chief Justice, if they're in the majority, or the senior most justice on the court, if the Chief Justice is not there with them. It's a weird thing, but it works very effectively. There is a lot of argument that goes on while writing opinions. Justices will conference together once they've basically voted on this and ensure that they're all putting across the same argument. What about if you're on the other side, though? Then you're going to write what's called a dissenting opinion. And that is going to explain what the minority's argument is, why thing X is not okay, why we are declaring thing X unconstitutional. And you can get another 4 arguments as to why that thing is unconstitutional as well. The dissenting opinion does not carry legal weight, but has sometimes been used much later on to argue other things. Dissenting opinions can also be used, Justice Scalia was very good at this, for basically giving a roadmap for how an appeal to this case should be made. So we declared this thing unconstitutional, but if you made this argument instead of the one you just made, we would have changed our mind. So maybe find another case similar to that and argue it differently next time based on this dissenting opinion. 9-0 decisions, so unanimous decisions, are set in stone. You are not going to overrule them. On the other hand, a 5-4 decision could be relitigated later on. It could come back to the Supreme Court in a different form, and that's where those dissenting opinions become very helpful. Once all those decisions are authored and the majority decision is produced by the court, then it is the chief executive's job, so the president's job, to enforce that ruling. Normally, the chief executive will do this. Think Dwight Eisenhower making sure that schools get desegregated in Little Rock. But there's nothing in the Constitution that forces the president to do this. Think Andrew Jackson with the Indian Removal Act. Justice Marshall said that the Indian Removal Act was unconstitutional. Jackson didn't care, did it anyway. Such is the power of the presidency. So I believe we've got this left, and then we're done. So how do rulings work? There are really 2 types of rulings. You got a narrow ruling and a wide ruling. There's no such thing as like a medium ruling, really. It's kind of one or the other. But they're going to determine how impactful the decision of the case is. Narrow rulings are going to deal with a very small, specific issue. So, for example, Masterpiece Cake Shop is the gay wedding cake case in Colorado. And the Supreme Court made a very narrow ruling on this. They didn't say whether or not the cake shop was within its rights to deny the gay couple the wedding cake that they asked for, because what the Supreme Court said instead was that, hey, the people you appeal to, the Colorado Civil Rights Commission, didn't do a good job listening to this the first time, so this case shouldn't be here in the first place, so go back and fix it. It's a very narrow ruling. It's not like anybody can look at that and say, okay, now we know what happens if a business discriminates against a gay couple. We have no idea, because the Supreme Court essentially decided not to rule on the case. They gave the most narrow ruling possible, basically against the Colorado Civil Rights Commission rather than against Masterpiece Cake Shop itself. So it's usually like, here's one very specific fix for one itty-bitty issue, as opposed to a massive fix. Wide, on the other hand, is going to be universal application. Gibbons versus Ogden says the legislative branch has power over interstate trade. Done. The ruling affects everything. It is a sweeping, massive change. Now, Brown versus Board of Education does not desegregate everything, as you guys will see when you watch that Loving video probably next week. Hopefully, you better watch it. Brown versus Board only applies to desegregation in schools, and on kind of tenuous ground at that. But it also shows that, hey, the court wants to go wider on this. So they might make another decision later on that will kind of feed off of this, if you will. We're going to use this as our guideline going forward. The Supreme Court is never going to decline to make a ruling on a case. They will just make a very narrow one. Or what they could do is say, hey, after we heard this, we actually agree with the state, so we're going to go with the previous ruling on this. Now, that is it for the Supreme Court. We've got one section left of notes here, and that'll be on civil rights, and that will be your last video for all of this. So hopefully you're all hanging in there, washing your hands, keeping up on your notes, right? Because I'm going to check those. And we'll go from there. So thank you all for playing along. If you have questions, leave them in the comments or shoot me an email. And keep checking Classroom regularly for assignments. And I will talk to y'all later. Adios.